Top of the morning to you. It's Thursday. Today is the 16th. I've been noticing, I should say, that the sun isn't coming up near as early. Oh boy, there must be a skunk over there. Don't go after the skunk, bro. Well, I guess if you're in the southern hemisphere, the sun's probably coming up earlier. But here, dawn is getting later and later. I used to be getting home when it was light out. And now it's still dark, just a barest hint of light on the horizon. Time keeps inexorably marching on. I love that people think that I'm giving up anything identifiable about my clients on these. This is a standing challenge. If you can identify them, then go ahead and post it in the comments below. Good luck. Nothing I've said in any of these cases are something that you're either going to be able to find online, because courts typically don't make family law cases readily available to the public. And none of these are in neither of the cases that I have given up any information on. They're not unique enough that you'd ever be able to figure it out. So, good luck. Speaking of those cases, I did have a chance to talk to my boss and another associate attorney about the holding that the order that the judge gave when he denied a pre-deposition judicial determination. And they both thought that it was a probable thing, and it doesn't say what I think it says, so that's good. So I understood it, that it would be almost impossible for the judge to narrow down the order like he had wanted me to do. And then he said he was going to do himself prior to denying the order. Because it's questions of relevancy. It's, you might be going down a path and asking questions where you find a relevant piece of information that you need more information on, and it's hard to say where those borders are going to be ahead of time. Which is one of the big reasons why I didn't try to limit it in my proposed order. So, the judge was facing a monumental, a Sisyphean task of trying to determine in advance where those fuzzy borders were going to be in a meaningful way that we could interpret, and all the parties would come to the same interpretation, etc. It's just not really feasible. So in denying it, from what these other more experienced attorneys were saying, the judge was basically saying, get her in front of you, ask your questions, and then basically let her assert the privilege, let the therapist assert the privilege, and then go back into court, file a motion to compel. It's going to be more, it's going to waste a lot of money. You okay, buddy? You got the sneezies? You get it all out? You got some of it on my leg too. That's nice. Yeah, it's going to be, we were hoping to kind of nip it in the bud and cost a lot less money, because experts, they charge for giving testimony at deposition or trial. This particular expert charges $400 an hour. We also have the added expense of having to hire a court reporter for the day, or half day actually, and they're pretty expensive. And then, of course, there is attorney time involved. You know, there's got to be an attorney in there asking questions. So there's a lot of expense associated with getting a person in there in the first place to say, I'm going to assert the psychotherapist patient privilege. And that's what we were hoping to circumvent by getting the advanced judicial determination. But what the judge is apparently wanting is he's going to want to see the questions we're asking and then make determinations when he has it in front of him. This question is good, you have to answer this question. That question is not good, you can assert the psychotherapist patient privilege on it, etc., etc. Now, that means if he grants a motion to compel on various answers, that means we have to get her back in. We have to ask her the same questions basically over again. We have to have the court reporter again. And you're like, well, why don't you just answer those or ask those questions like with an interrogatory or something like that? Well, even if we could, and I'm not sure entirely that we could, because she's not a party. But even if we could, then the follow-up questions, how do you ask follow-up questions in advance on something like that? So it's just, the court doesn't really care about pocketbooks. I mean, I guess maybe it does, and sometimes in circumstances, but in this particular case, it's I could understand. And the domestic violence restraining order, it appears that we are going to appeal it. We are going to do it for a flat fee, which is kind of good and kind of bad. It's kind of good in that you don't really have to worry as much. You still have to actually bill your hours, because if you don't bill the hours up to the maximum of that flat fee, you got to return it. So obviously we're going to be doing that. But it takes a lot of the pressure off. Believe it or not, you know, I bill a lot of 0.3s for reading a 30-page case. Finding, reading, and understanding a 30-page case, an opinion. And that's not 0.3, that's probably like 0.4, 0.5, you know, in the time you go in to find it, make sure that it's on point with what you're looking for, and then start reading, make sure that the fact pattern is sufficiently in line with what you're wanting to do, make sure the holding is in line with what you're wanting to do, and then read through it with specificity, looking at the language to make sure that it doesn't throw you any curveballs, etc. And I charge a lot of 0.3s, 0.2s, 0.4s when I should be charging 0.1 or 0.2 over what I'm doing, because oh boy. Barky dogs. Barky dogs. Anyway, so I charge less because it's amazing how clients get upset over, you know, you charged me to read my email. Yeah, that was 0.1 to read your email. You charged me to talk to me on the phone. Yeah, I'm working. That's me working for you. That's the point of this. So having that flat fee means that, you know, if it actually takes me 6 to 8 hours in the law library looking up just to find the exact right, most perfect case, then that's what I get to do. So that's a good thing. I'm kind of looking forward to that. It'll be my first California Court of Appeals case, so that's fun. It'd be great to take this all the way to the Supreme Court. It'd be terrible for my client's pocketbook, but I'd enjoy it every step of the way. Let's see. Bunny Boots, he posted the oral arguments in the Court of Appeals case for the Askins v. Department of Homeland Security. So, good morning. Come on. Come on. Come on. It's funny, those in that oral argument, the judges and the lawyers, they go on and on and on about forums. It's like they did a 10-minute Google search. They found forums, and that's all that they know how to talk about. Obviously, I'm paraphrasing all the auditors who, and it's not really the auditors, I guess. It's all the auditor sycophants who come into my channel thinking that I don't know my asshole from my elbow. Are you done? Are you done being in the way? Good. Who think there is some other metric by which we look at public photography other than through the lens of forums and forum analysis. But that's precisely what that California, or no, that's a federal, that's the Ninth Circuit Court of Appeals. That's exactly what they were looking at it through. It was that lens itself. So apparently, I'm speaking the same language as other lawyers and judges are when I'm talking about forums, and I'm asking people about forum analysis. So there you go. Anyway, I guess that's probably good enough for today. 12 minutes, almost 13. Be thankful for what you get. I wouldn't expect anything out of me this evening. I'm gonna have to try to go to sleep early, because I'm gonna be getting up. I haven't quite finalized it yet, but I have a feeling I'm gonna be getting up at around 2:30, 3 at the latest, to be off to the races in time to, you know, gotta be at San Mateo Court at 9 a.m. 9 a.m. Good times. Anyway, thanks for watching. Have a great day.